So the Supreme Court thinks that it's okay for you to access files that you don't need to access just because you have authorization prior for a reason when you have that reason. I can go and look up your docs if I have access to it just because I have access to it. Okay, that's a bit hyperbolic, but in essence, kind of the truth of what the Supreme Court is saying in the case of Van Buren versus the United States. Nick Rekieta of Rekieta Law had this video out over the weekend, and I watched it, and I just boiled and seethed, and I even already recorded this once and was in the middle of editing it, and I was just like, no, this is not what I want it to be. I don't want it to necessarily be a rant. But at the same time, I must acknowledge that a rant is going to be a part of this just for the simple fact that I don't agree with the justices that made the majority opinion on this. And the reason why I don't agree with it is because I think that they are lacking. They don't think, or they don't appreciate that the law should have some sort of level of common sense to it. That is to say that if I commit a crime, like a legitimate crime that carries, felony or misdemeanor convictions with it, or consequences with it, it should be covered under this law that they're discussing in this case. If I violate a terms of service contract, then it's not a crime, it's a contract violation. And I understand why they're doing this. When you hear which law I'm talking about, when you hear about this, you'll be like, well, they're concerned not about the criminal side of it, they're concerned about the civil side of it. This is where the law, and I agree with them, this needs to be changed by Congress. But this is where they can say, we're interpreting it this way because it's muddied, but it's a case-by-case basis. This isn't going to be this is the rule, clear cut. And the Supreme Court should be able to do that. The Supreme Court should be able to say, okay, look, here's this, and then they can have Congress initiate a review of the law and have it reworded, rewritten, clarified even. Because ambiguous laws do not help anybody. Ambiguous laws do not help you. They do not help me. They help businesses all the time, apparently. And they apparently now help criminals. But what am I really talking about today? Today I am talking about the Supreme Court docket case 19-783, or as I said, Van Buren versus the United States. Now this is page one of the PDF, page one of the opinion, yada, yada, yada. I'm just going to jump over here to page 9 really quick, because this is where I think that it actually starts the actual issue of the case, okay? Van Buren was a police officer who took a bribe of $5,000 from a, lack of a better phrase, an informant for the FBI. This informant is somebody that didn't really care for Van Buren, but, Van Buren came to him, long story short, Van Buren took money from this guy to look up a license plate that was bogus because it was planted by the FBI, and signaled that he was ready to give the information to the informant. And that's when he was arrested. The law at question here is U.S. Code 18 U.S. Code 1030, specifically dealing with section A2. It intentionally accesses a computer without authorization or exceeds authorized access and thereby obtains. And then we go down to E6. Come down here where we have E. It's the terms of the cert, or terms used in the law as they're defined. And I will go over this in a second, but I want to kind of discuss what I have done here to research this. I have, watched Nick Rekieta's video. So that does mean that there is a bit of a bias there, because I agree with him and I agree with the dissenting judges on this. 2, I have actually listened to the oral arguments presented by the attorneys for Van Buren and the attorney for the state. And then let me get the other thing. I also, and because I have it in a separate window because I was listening to it and reading the actual transcript. Links to all of the information that I have done for this are all located at supremecourt.gov, but I will link the individual information, including access to the amici briefs. So, and while these are three that I have read, they give me enough understanding of what it is that the Van Buren side is talking about, and I understand why, but I don't see that where the court was supposed to be discussing the civil side of this law, because this law does actually have a criminal side and a civil side. And the point of this was actually the criminal side of everything. So let's get into this. The Computer Fraud and Abuse Act, also known as 18 U.S. Code 1030. It basically is when you use a computer to hack into a system or you use your credentials to access files. There will be examples in here that I will go over. I should say over, but there will be examples that I'm going to go over in here that I will try to my best to give an analogy of my own. Yes, analogies are flawed, but at the same time, I think it can help you understand my reasoning for my opinion on this. So, starting with Section 2A1 here, both Van Buren and the government raise a host of policy arguments to support their respective interpretations. But at the start, we start where we always do, with the text of the statute here. Here is the most relevant text in the phrase, quote, exceeds authorized access, end quote, which means to access the computer with authorization and to use such access to obtain ellipse information in the computer that the accessor is not entitled so to obtain. Now, I'm just going to kind of jump to the point here. They're focusing on these two words here. Well, yes, they're technically focusing on the phrase, so to it's titled so to obtain. They're really coming down to these two words, entitled and so. Okay. And let me jump over to the full definition, just so we have the full definition, no paraphrasing, nothing. The term, quote, exceeds authorized access, end quote, means to access a computer with authorization and to use such access to obtain or alter information in a computer that the accessor is not entitled so to obtain or alter. Okay. Now, let me also jump to my opinion on this. If I access a computer system that I have access to for work-related stuff, I do not have access, or I do not have authorized access to actually access that information for personal reasons or personal gain in this concept of a bribe. Like I said, there is an example here that I'm going to go over in a bit, but I think that in this case, Van Buren, who looked up a license plate to get personal information on a fictitious person for an informant, took the bribe, signaled that he completed the thing, and he did, has committed a crime of computer abuse. Not fraud, computer abuse. Fraud would be the altering of the information. So, all right. The parties agree that Van Buren accessed a computer with authorization when he logged into his patrol car computer and valid credentials into the login in the law enforcement database. They also agreed that Van Buren obtained information in the computer when he acquired the license plate record for Albo. The dispute is whether Van Buren was entitled so to obtain the record. Entitled means, and they give the definition here from Random House Dictionary and Black's Law Dictionary. The parties agree that Van Buren had been given the right to acquire the license plate information, that is, he was entitled to obtain it from the law enforcement computer database. But was Van Buren entitled so to obtain the license plate information as the statute requires? And that's where I think the hang up is where they're going from a criminal to a civil issue. The criminal obviously is what it sounds like, fines and jail time. The civil is I could actually owe, if I say worked at a, well, the law does specifically say financial institutions. Let's say I have access to your social security number because I'm an HR rep and I'm doing personnel evaluations, and to make sure I have the records, yada, yada. While I'm doing that, I also happen to, as part of my job, be able to check do like a soft credit report. I don't know that that's actually the case that HR reps can do that, but just hypothetically, let's say we don't want people who with poor credit scores because we're afraid they'll leak proprietary information or whatever, But let's say that as part of my job, I'm doing a soft credit check. Oh, you have a nearly perfect credit score. I jot down your number on a piece of paper. Jot down, Joe Smith's down the hall, Jane Doe, Susie Q, so on and so forth. I jot down all your social security numbers. And then I could go out and sell them to somebody. I would be liable not just for computer fraud at that point, but I would also be liable to you for the damage of your identity theft issues. And that's where they want to segue this, but they use, in my opinion, bad analogies and bad argumentative reasoning. As the government lawyer states, they use a parade of horribles in their argument. So, anyways, Van Buren says yes. He notes that quote, so, as used in this statute, serves as a term of reference that recalls, quote, the same manner that has been stated, or, end quote, or, quote, the way or manner described, end quote. And they, again, cite Black's Law Dictionary. The disputed phrase, entitled so to obtain, thus asks whether one has the right, in the same manner as stated, to obtain the relevant information. Okay. I'm going to jump down to their example here. Basically, what they're saying is that if somebody has the right to access the information, i.e., if I have credentials to access computer folder Y and all the files located within there, it is permissible for me to pull those files. I do not violate the CFAA by obtaining such information, regardless of whether I pull the information for prohibited purposes. So the Supreme Court here is saying, by the majority opinion, is saying that it doesn't matter. You can abuse computer privileges to pull from files that you normally have access to. It doesn't matter whether you're doing it for proper reasons or improper reasons. You're not able to be punished by this. And part of their reasoning is that there are other laws to cover this. The problem with that is, though, is you have clearly here in the wording the entitled so to obtain. You just because you have access does not mean that you have the entitlement to obtain at any time. There is implicit in your credentialing when you can actually access information, when you can actually use that information. And one of their examples of what not, or the defense's, or I should say the petitioner's points is, if you use your professional email, i.e. Joe Smith at Yahoo, or not Yahoo.com, Joe Smith at Amazon.com, for personal gain, or for personal reasons, you have violated your company's policy, and therefore, if we interpret this situation with the license plate as a criminal offense, then so too you using because you violated your company's policy, you are now subject to a federal crime. No, you're in violation of a company policy, not a criminal act. And I think that's the Supreme Court is supposed to narrowly decide things but keep things, openly as broad as possible in the laws. And I get that. But at the same time, they're also supposed to make sure that the laws are just and fair to people. And this, using your professional email for personal reasons, there are a host of reasons that even companies will grant you using your professional email for. For example, say that I wanted to surprise my wife with a vacation trip to somewhere she really wanted to go. And I have a business email at my current job, let's just say. I use that to talk to my travel agent or use the internet at work to book through Travelocity, whatever. I'm just like, when I fill it out, I use whatever form I fill out, I use my work email instead of my personal email. I do everything through my work email. Well, guess what? My employer might be like, you shouldn't be doing that. But if I explain, hey, I'm trying to surprise my wife and she has access to the computer at home, and if she sees that, in my email, because, yada, 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 my employer might be like, okay, just don't do it again, or at least talk to us before you do it. So that way IT knows that this isn't some malicious attempt to get into the system. Those are valid concerns for a business to have. But those are also understandable reasons why an employer would not punish you for violating their policy. Now, if I'm using it to set up, buying drugs or soliciting other things, that I shouldn't, it's understandable that they would terminate my employment and they would not be so forgiving. The world of the law and the world at large is not black and white. It is a lot of gray area. And it is up to the courts to help clear up that gray. It may never be black and white, but it could be a lighter shade of gray that is, okay, these situations are obviously going to be violations of this law. These situations, oh, come on now, please be real here. So continuing on with their example here. But if the information that I pull for your personal information is instead located in folder X that I do not have access to, then I'm violating the CFAA. But that's just it. If I'm, and again, the premise of this law, and I should have started with this actually, the premise of this law is actually anti-hacking. In the late 70s, early 80s, when the internet and everything was becoming, I wouldn't say mainstream, but more known, and you could actually do things like Matthew Broderick's character in War Games. You could dial up, several computers all around the world and hack into systems, backdoor them. This law was designed for that. But in the modern day, we need to have this law updated to basically say, okay, if you're doing something that is criminal, this is the case. And if you do something that causes damages to a company that is due to your criminal action, then they can come after you civilly. Not, oh, you violated Twitter's terms of service because you said you were some, I don't know, you were William Shatner. You were doing a parody account of William Shatner, but you didn't make it clear that it was a parody account. That's not, in my eyes, that would not actually be a violation of the CFAA. But according to the majority opinion, it would be. So, all right. Now I'm going to jump down a little bit further here. And where are my... I should have had these pulled up ahead of time. I'm going to go to page 14 and 15 of this dissent, or of this thing, where they talk about the dissent's approach. And I think they're strawmanning the dissent's position here. Because, again, the dissent is not trying to say anybody who violates access for any reason is going to be criminally charged. They're trying to say, look, we have to understand that in the time that this was passed to the present, things have changed. We should actually be making sure that in order to obtain access to a file, you actually have to have a reason, a valid reason that your credentials are given to you for. So Um, and actually, let me start on the previous page with this previous paragraph. 3. While the dissent accepts the Van Buren's definition of so, it would arrive at the government's result by the way of the word entitled. One is entitled to do something, the dissent contends, only when, quote, proper grounds, end quote, are in place. And they talk about the dissent's position on this, which is a part of this document. And quoting Black's Law's Dictionary again. Deciding whether a person was entitled to obtain information, the dissent continues, therefore demands a quote, circumstance-dependent, end quote, analysis of whether the access was proper. Again, this is where I agree with the government's attorney and the dissenting justices. Just because I have credentials to access doesn't mean that I have the right to access. It doesn't mean that I have at any given time to be able to access this information. If a police officer just randomly pulls my license plate for no reason, they have no probable cause, and they arrest me for whatever reason, they have to have had a reason to pull my information. Otherwise, it's a violation of my Fourth Amendment rights. Let's say that they're like, oh, this person's speeding and swerving all over the place. They're probably drunk. They pull me over. They run my license plate. That's a valid reason. They've had the probable cause. Now, I might have a very layman understanding of the Fourth Amendment, but my general understanding is that when it comes to cars and vehicles, it's not as strict as it with a house. You know, like if a police officer comes up to my house because they've heard rumors that I'm doing something, but there's no way to prove or give probable cause other than, oh, it smells funky over there, and he's got a pile of garbage outside his house. No, that's a bad analogy. Let me rephrase it. Basically, if a police officer just comes up because Jane Smith says that I'm doing crack, that's not always going to be a valid reason. They would have to come back. I could deny them access and be like, do you see anything here that actually warrants this? And if their answer is no, and I tell them, fine, go get your warrant. They have to show the probable cause to come in. If they come up to the window because Jane Smith says it, and they see a crack pipe sitting on my kitchen table, or say my living room coffee table, and it's clearly out and visible where anybody could see it, that gives them probable cause. You know, that's my understanding of how that works. But just because somebody gives me a license plate number and says they'll give me $5,000 does not give me probable cause or a reason to access that file. It would be just like as if, HR person, oh, hey, I know you work at this company and I know you have a lot of people who have good credit. I'm down on my luck and I could use some extra stuff. I just need to do this. And I know you're hard up for some cash too. How about I pay you $5,000 per person and you give me their information so I can go steal their identity? I may not even tell you that I'm going to steal their identity, but basically implying you give me information that you don't normally otherwise have access to give me so I can give you money. That's a personal reason. And my access does not cover that per my company's policies. That's the type of thing that I overall think that is missing from the majority opinion, is that they don't want to acknowledge that this is a possibility. So, the dissent's approach on the word entitled fares fine in the abstract, but poorly in context. The statute does not refer to, quote, information that the accessor is not entitled to obtain, end quote. It refers to, quote, information that the accessor is not entitled so to obtain, end quote. And again, now we're focusing on the so instead of the entitled. Emphasis added, yada, yada. The word entitled then does not stand alone, inviting the reader to consider the full scope of the accessor's entitlement to the information. The modifying phrase of so to obtain directs the reader to consider the specific limitation on the accessor's entitlement, which is exactly the point. It is exactly the point of the situation. Does this police officer have the right in their entitlement, in their credentialing, to access this license plate for personal reasons that are not probable cause? Basically, does this police officer have the right to abuse his computer access to violate your Fourth Amendment right? The majority of the Supreme Court says yes. Yes, because other laws do cover this and prevent this. Obviously, policy terminates that would cause them to be terminated. That's not the point. The point is now you're basically saying, oh, yeah, okay, I'm not going to get an extra 10 years tacked on or concurrent. I'm not going to pay an extra fine on top of this. Oh, and now if, say, I did this before I got caught a couple times and that I now don't qualify for paying damages to the people that I've caused harm to. What if Albo was stalking, like seriously stalking somebody? The premise on this was that he found that he's talking to a person online and basically got the license plate because the person lives close enough, but didn't want to seem stalker enough to track them to their house. So, I mean, come on now. Seriously? And basically his entitlement to obtain the information in the manner previously stated. That's just it. The law is so vague that it's inviting you to understand that you may have access, but you may not have access at the same time, depending on the situation. But that's not how they're reading it. And as already explained, the manner previously stated is the using of a computer one is authorized to access. Thus, while giving lip service to Van Buren's reading of so, the dissent, like the government, claims to give so any limiting function. No, that's just it. They're giving it more limiting function. They're trying to say that you're entitled to do so long as you meet the requirements of your credentialing. And that is where I think the author of this opinion, Amy Coney Barrett, oh no, the last Trump appointee, oh no, has got it wrong. Along with Gorsuch and Kavanaugh and the 3 other liberal judges. So 6 of them don't understand that just because you have access does not mean that you have access carte blanche. Doesn't mean that you can just access it whenever you want to. So, the dissent cannot have it both ways. The consequence of accepting Van Buren's reading of so is the narrowed scope of entitled. In fact, the dissent's example implicitly concedes as much. They all admit the word so, thereby giving entitled its full sweep. No, I'm not going to say they don't. I'm just going to say that they're not omitting so because it has no value. They're omitting so because they understand that so is the limiting factor. So if you are entitled to obtain the information for legitimate reasons and you do so without those reasons, then you are not entitled to obtain the information. You are not so entitled to obtain that information. And that is, and that's the point that I think is that is the point I think they miss. The government falls back on what it describes as the common parlance meaning of the phrase exceeds authorized access in their brief. According to the government, any ordinary speaker of English would think that Van Buren, quote, exceeded his authorized access, end quote, to the law enforcement database when he obtained a license plate information for personal purposes. The dissent, for its part, asserts that the point settles the case. And it does. If you go and listen to, and it's an hour and 6 minutes, but it is worth the listen, and I highly recommend reading the transcript while you're listening to it. if you read it, you understand that the justices all are understanding what the government's position is. And it is not that we're trying to make it so that you violate the terms of service, you get criminal charges. No, if you're committing a crime that is not covered by your credentials to log into this, you are committing a crime of the bare minimum, in this case, computer abuse. Damages, civil damages are not a point. Violating your terms of service with your employer or any oral agreement with your employer, because if your employer comes in and says you can't use your computer from this time to this time because this is when you're usually watching YouTube and it's on your lunch break, or mom and dad tells their kid you can't use social media while you're doing your homework online. Well, if you break that, you've committed a felony. I mean, honestly, the arguments that they give in this is just asinine. This is just garbage of an opinion, and that's my opinion, because they're not willing to challenge. They're not willing to understand that in this instance, the point of the matter is that somebody is committing a crime with a computer. They're using access credentials that, yes, they have, but they're exceeding that access by doing it for improper purposes, which they are not entitled to do so. So if I am entitled to so obtain for reasons that have to be specified, especially in the case of a fucking government, then if you use it for reasons that are not those reasons, i.e., I'm taking a bribe and I'm going to give somebody's personal information, I'm fucking doxing somebody, you fucking violated this law. Just because I lie, and one of the great arguments they were using, fucking dating sites. If I claim that I am somebody I am not, if I say that I am 6'4", 200 pounds, muscular, red hair, all this great, wonderful things, I go and meet a woman, and turns out that I'm myself, 5'11", 270 pounds, and all that. She has a right to complain about computer fraud and abuse? No. That's just me lying. I mean, that lying technically is not a crime, depending on the situation of what it is. What they're trying to say is that all lying is a crime. Period. Full stop. So even by their own logic, when you're a kid and you got busted with your hand in the cookie jar eating cookies, you broke federal law by their own logic, in their opinion. Because if all lies are a crime, every lie, including even lies for people with top secret clearances that can't tell positions of things, i.e. a submarine, I have broken the law. So, and just to finish this up on an analogy of access, okay? So going back to folder Y and folder X access, okay? I was the ship's photograph petty officer. First, I was obviously assistant to the previous guy, and then I took over from him. And this was all before the subs were integrated, so yes, it was a guy, at least as far as he went by at the time. I don't know. I assume he still goes by being a guy at this point. Anyways, long story short, try not to misgender anybody. The point I'm trying to make is that there are certain spaces on the submarine that I could gladly take pictures anytime, no matter what. There are certain places I'm only allowed to take pictures when directed and authorized. and I have full access to the ship for just about any reason on my own anyways. Generally, I don't need to be back aft in the engine room, but there are times where it's like, oh, hey, there's maintenance that needs to be done there, or hey, I'm bored, my friend is on watch in the engine room. As long as I don't distract him from his job and doing his job, I can go back there and shoot the shit with him. Just like when he's bored and I'm on watch, as long as I wasn't at the plot while we were actively doing our deterrence missions, he could come up and shoot the shit with me. There's certain things where you have a need to know that limit your access, obviously. But I couldn't just go back there with the camera and take pictures whenever I wanted. You see it all the time, these people that are qualifying and taking pictures of the engine room because they don't have the ability to memorize things like they need to. Well, if I had gone back there and taken pictures willy-nilly of, the shaft or the shaft seals, the steam turbine generators, the distiller, the 3K and the 12K distillers, if I took pictures of any of that, let alone anything related to specifically the reactor, I would have been at best only a captain's mast and stripped of my photograph petty officer status. Worst, court martial, time in Leavenworth, reduced in rate, and at best in that situation, other than honorable discharge, if not a dishonorable discharge. The point is just because I have access to something for any particular at any given time, or just because I have access to get it in there for a reason with something, i.e. taking pictures when something's broken and we need to do something about it, send messages off, etc. Or if I just go back there because I want to with the camera and take pictures, I don't have a reason to be back there. I don't have a valid reason to be back there. I'm not covered in that sense. Is quite literally the worst interpretation of this law that I can perceive. And I know, short of another case like this happening, they're not going to come back and revisit this. But, and this isn't even an issue of political affiliation or anything. This comes down to the fact that we would rather err on the side of letting you break the law just because we don't understand technology than it is of you broke the law. Here's why. Common sense dictates that if you violate a terms of service with Twitter or you violate a company policy, you don't actually fall into this category of a federal crime because it's not the same thing. Oh God, it's just they're trying to deal with the law being black and white, and it's not. So it's not clearly A or B. It's A through Z, and then any sort of subcategories below that. You have to be like, okay, this case, Van Buren, is clearly, obviously a crime. Didn't have access to it because it was for personal reasons and a bribe. Okay, fine. That's a crime. Settle it with the criminal side. If there were actually damages to somebody, make sure that they sue civilly. Okay? If I violate Twitter's terms of service because I have an account after account after account because they're trying to IP ban me, that's not a crime. That's just me not wanting to acknowledge that I agreed to a contract to begin with. And really the only harm is that my profiles take up some space temporarily that they could just purge once they've realized that it's not a thing. Yes, that's man hours, I guess. So there is some sort of damage there. But if Twitter's going to sue every violator of their terms of service, how are they going to pay their legal team, their legal expenses? They're going to have to charge for Twitter at that point. And the same thing for Facebook, the same thing for YouTube, the same thing for Twitch, BitChute, Gab, Minds, Parler, all of that. My employer is going to have to spend time, legally charging me for civil charges for using my work email for personal purposes, or using my work internet access for personal purposes, for violating their policy. Or they could just do the easier thing and fire me. So, I mean, it really, Justices Sotomayor, Kagan, Breyer, Gorsuch, Kavanaugh, and Barrett, maybe understand what access really means in the term of what credentials are and why you have them. Just because you have access to the system doesn't mean that you have full access to the system at all times. So this has been a rather long, less ranty version of this video, but still, I think the point is made. This is a bad decision by the majority, all because they think that businesses are going to go after it, and businesses might. But they have to ultimately prove that because you violated the terms of service, you've committed some sort of fraud, or you committed some sort of abuse. It's one of those things. And technically, with their use of the internet as a whole, a lot of websites are based in the U.S., like Twitter and Facebook. So does it mean everybody now that accesses Twitter via their phone or their computer in other countries are subject to U.S. law? Probably not. But I mean, the argument's now there that they would be. So they'd be subject to the CFAA. I mean, I would love to sit down with Nick Rekieta or OPT lawyer, and I know what OPT lawyer is going through, and I wish you the best and speediest recovery, man. Kick cancer's ass, man. Just put it in a fucking sleeper hold and snap its neck. That's the way I feel about cancer right now. And, I wish you the best. I would love to sit down with Robert Barnes or any of the YouTube lawyers that I like. So, sorry, Legal Eagle, you're out. I don't want to talk to you about this. Although I wouldn't, if I find out that you actually do a video covering this, I will actually watch it because I think that you would provide a great counterbalance to me. But I would love to sit down with a lawyer, a practicing lawyer, and actually discuss this with them and see what maybe they can educate me on why I'm wrong, in my opinion. I know Nick Rekieta agrees that it's the majority opinion is wrong in this case, but he has a more nuanced understanding than I do, and maybe he could help me understand, or maybe he can explain better why they're saying that these would be violations. And again, I think it really comes down to the breakdown of criminal versus civil penalties in dealing with this law. And I don't think that every violation of terms of service would be a civil violation. And I sure as hell know they're not criminal. So with that said, sorry that I haven't been posting as much. I am starting up a business that I just don't want to promote here. I don't want the two entities mixing as much as possible. I know that it's impossible to expect that to happen forever, but I just know that I don't want to actively promote it here. So yeah. So if I'm not posting as much as I said back in February that I wanted to do, after I finished up school and all that, this opportunity for my business is more important to me than making money here on YouTube. So with that, thank you for watching. Have a great week. Rest of the week. Have a great weekend. And if you really, really love law, go check out the Supreme Court website. There's a lot of great audio there, A lot of great transcripts. You have access to all the briefs. Well, most of the briefs, you know. It's really worth it. So, with that, take care. Have fun. Peace.